Well, thanks first of all for having me here and for being able to present to you the defense perspective. Many of the topics that I'm talking about today, we've already touched upon yesterday, but I hope I can give you somewhat of a little bit of a different angle. I am mindful that effectively we have 10 topics, 5 subtopics, and defense and compliance perspective. So it's very good that we have a solid basis from the discussions yesterday, so I can touch upon individual issues that I consider relevant and current topics from a defense perspective. So that's our agenda. It's packed, so we don't waste time on that one. Sanctions. Sanctions is obviously a very much relevant topic at the moment for very obvious and, well, disappointing reasons, of course. But if we talk about sanctions and compliance, that is a huge challenge to companies at the moment. And why is that so? We talked about the FAQs yesterday, so I'm happy that the groundwork was made on that. And also we've heard some questions yesterday, what the challenges are for the companies at the moment. To be honest, it sounds pretty straightforward, doesn't it? Well, you have to perform appropriate due diligence, but then it gets more complicated. You have to go to the specificities of the business and the related risk exposure. Now, that's very generic terms, and I'm absolutely clear that and convinced that it is very difficult to make this more specific from a EU perspective. However, for a company, these are very generic terms, and for different sized companies with more or less legal background or not, it is very challenging to fill these terms with a practical relevance. That being said, of course, while you have this broad discretion in how you implement your due diligence and your compliance within your company, you always run the risk, and these are quite significant risks depending on which jurisdiction you're in, of running into fines, freezing orders against your company, having significant impact on your company. So let's just be practical in the first place. What's the tone from the top? What's the culture you want to give to your company as an executive in terms of the sanctions? In order to do that, you need to understand the rules. You need to understand the goals that you want to achieve with your compliance system. You do want to find out what the risks are. Again, these are significant and can be very detrimental to individual companies that are dealing with these topics. And we will see it's not always that straightforward. It's not clear in all cases where the risks are and when you cross the line. On that basis, you have to implement your program. You have to do your organization, reorganize possibly. That is, teaching, that is doing compliance seminars for your employees and so on. So there's quite a lot of work coming up. Of course, you have to communicate. You have to communicate clear rules. Again, you need to understand the whole sanctions regime in order to clearly communicate the boundaries and where people can go and where they couldn't go. And lastly, obviously, you have to monitor and improve. And I think that's something that we'll get into in just a couple of minutes. Now, if you look at the risk exposure, that has increased significantly. You've got, and I fully understand that, the EU, we've seen it yesterday, the sanctions map is priding itself with having 4,695 individuals on its list, 35 sanctions regimes, 79 nationalities. That is a great effort from the authorities' perspective. That is a huge challenge to an individual company. If you look at the multitude of sanctions that have been imposed in all various sectors. Now, the challenge that I find most relevant, and that topic also was mentioned yesterday, is the topic of circumvention. Now, that's relevant in so many ways. If you look at your compliance program, how do you organize your company and how do you review actually the conduct of your employees? How do you calibrate your systems in order to prevent a circumvention? What we see and what data statistical data suggests is that a huge part um, could actually of goods delivered to Russia could actually be delivered via other countries. Some of these are named here, involving also, for example, which is not listed here, Turkey. Now, how do you find out if your counterpart in Turkey is intending, or any other country, is intending to on-sell the goods that you've sold to them to Russia? Is it enough if the other counterpart makes a bad joke about, oh, well, this is going another way? Does that mean red flag, can't deliver anymore? Or was it just a joke? Now, that joke is probably being made between some sales officer or employee of your company and not yourself, possibly. So how do you even find out? I'm coming to whistleblowing in a second, possibility. But as an employer, as director of a company, this is a huge challenge. And again, if you want to improve your systems, if you want to supervise your employees in some way, how do you do that? That's often orally. These are jokes. These can be unofficial arrangements even. I would guess, I haven't seen these cases in practice so many times, but I would guess that no one would be as frivolous as to write into a contract, I'm on selling these to Russia or something. This will always be informal contacts. So again, this puts you into a huge challenge of how to actually control and get this, what the FAQs require, that is an effective due diligence process. Circumvention, again, is something that is not even defined in the regulations. And that coming back to the risk exposure, and there's different approaches to my understanding as to criminalization of circumvention. In Germany, it was considered not clear enough as a concept to prevail, and this is why initially a criminal regime on that was quashed, and now circumvention itself is not a criminal offense in Germany. And I would be very interested to hear in the questions afterwards how your jurisdictions cope with that and whether possibly it is in your jurisdictions. I understand that there's some harmonization going on. Understood that from yesterday. And I think that is very important to have a fair practice for everyone involved. Another topic of fairness, and probably you can imagine that this topic is coming up today when a criminal defense lawyer is coming up and discussing things with you, is the ban on legal services on legal persons, entities of bodies established in Russia. So there's a complete ban on providing legal services with one exception, and that is strictly necessary services for the exercise of the rights of defense in judicial proceedings. Okay, so as a lawyer, please take my position for a moment. Judicial proceedings, so you need to have an issue before you even start advising your client. It needs to be for the exercise of the right of defense, so it's very limited, cannot go left and right, and it must be strictly necessary. Now, what is strictly necessary? This is a highly complex area of law. Now, if you talk about hourly fees of a lawyer, is it necessary to have X, Y, and Z as a fee? Is it necessary you did a research, so on? You get into very, very quickly as a lawyer, you get into gray areas, which are not really sufficiently clear from my perspective. And there's another issue to this, obviously, is it's only within the judicial proceedings. Now, what do I do if a Russian person or a Russian entity comes to me and wants my advice before we go into proceedings? Well, let's just assume I'm asked to give an opinion whether tackling some kind of ban or some kind of freezing order will likely be successful. That's what I usually do. I would advise the client, is there any chance of success of going against this? Can I do this under this? ban, I'm not so certain. I wouldn't feel comfortable with that. I'm not doing it at the moment. I'm not representing Russians for my own reasons. But I think as a general matter, it's a very wide ban. It's extremely difficult to maneuver as a lawyer, and I'm hearing from many of my colleagues that they're having real serious problems with these topics. And in general, as a matter, and this is why this is has been taken also to the European Court now, on the basis of proportionality, on the basis of foreseeability, on the basis that Article 47, the right to effective legal remedy, is being challenged. And I think the oral hearing was just a week or two ago on this one. I'm very interested to find out what the court will think about this. So happy to have a discussion on this later on. So we continue our little good morning gallop here, and come to the matter of money laundering and CTF. Sorry for keeping this in German. I'll translate it to you in a second. But the thing that I wanted to talk about to you is AML. We've heard it yesterday on several occasions, plays such an important role. If you exclude the sanctions regime, which, as you can see, exploded literally, again, for very obvious reasons in recent years, then you will see that AML is the main trigger for sanctions for companies. So that effectively is the area you want to be compliant in. Now, for example, if you look at Germany, we've talked about Wirecard yesterday, and the German regulatory body, BaFin. They have had some trouble with the AML proceedings. They have very much picked up their business. They have increased the scrutiny. They are now continuously targeting, in particular, fintech companies and fining these. As you can see, the one is a fine against a company called Solaris, which is a fintech. They paid, what is it, 6.5 million euro. But you've also got the big figures or the big names like Deutsche Bank being fined. They were having increased problems for many years with their AML systems. But you also again have the, well, fortunately all Berlin-based N26 Bank that has been fined also in connection with the money laundering. So what you do see is an increased scrutiny on banks and fintechs in particular. However, there's one point that I, as a defense counsel, cannot stop from saying, and that is you are seeing the regulatory side on this, and you are seeing that banks are being fined for failing, for example, to file their suspicious activities reports on time. However, the personal equipment of BaFin and in particular FIU has been so poorly equipped in the past that it even occurred that they had up to 300,000, I think it was, unfinished cases, reports that they had to deal with, which in turn even triggered a prosecutor in the rather small city of Osnabrück to request and actually acquire a search warrant against the German Ministry of Finance, the German Ministry of Justice, and the FIU, I think 2 years ago, which I think is very indicative of what is happening here. A certain disbalance that I consider is that you have all these fines against the companies for not reporting early enough, but then things end up with the FIU and get stuck there for quite some time until they're handled and until they're forward on. It is very important to see that this case number, this backlog has decreased significantly. I think it's down to about 100,000. That's the latest figure I saw. Still sounds quite a lot, but they've increased numbers and employees very much. So I'm hoping that there's something coming out there, but I hope you understand my concern in fining banks for not reporting immediately, but then leaving the things hang to dry for quite some time. Now, one thing that I found very interesting, also with a view to harmonization, and because I think also here it's important to have, a unified European approach to it, is the planned AML directive, which will, as we heard yesterday, and this is why we'll keep this short, include further regulation on the crypto sector, luxury goods, the football sector. Well, I wonder if it's only football or should be sporting in general, but that's obviously big money. So there will be some regulations in there, and obviously also limiting cash transactions to 10,000 euros, which, well, won't really change our daily business, I think. But given the amount of cash we saw in the lockers yesterday on the pictures from the seizures, I think it's a very mindful exercise of limiting these transactions. If we turn to anti-bribery and corruption, and I think that is something where quite a lot of, again, future exercise also in the field of compliance lies. This is a new field, and I feel, and again, I would be interested to see how you feel about this, but this is a field that I feel will be very much of relevance in the next couple of years, from a compliance perspective, and then obviously later on also from a criminal prosecution perspective. That is ESG compliance. You've got all the new directives and regulations on financial and non-financial disclosure that force companies to make certain announcements within their respective reportings. Within their respective reportings, forcing them to make statements about what their business is about, what they do in terms of sustainability, and how their businesses affect the environment, for example. This is, I think, quite a unique exercise. We talked about good doers yesterday, and do-gooders, I think you call them, about those who want to go out already now, pointing out how good their company is, how good they do, how well they protect the environment. Well, that obviously partly, at least, will be subject to these new laws. When we do get the green claim directive, which is still a proposal, obviously hasn't been enacted yet, but at the latest when we get that, it will of course be super difficult for companies to claim that their product is green, that their product is environmental friendly, CO2 neutral, and so on. So what you have is a huge field where right now, I would believe many companies are, let's say it nicely, on the verge of, probably being too green for what they are. And when we talk about green, I think the biggest impact of all of that probably was the green diesel, right? So, which possibly wasn't so green anyway. So that is where I think partly this all comes from, but which will cause a lot of trouble to companies modifying and determining their risk exposure for their compliance systems, because they will have to disclose quite a lot, and they are going into quite a lot of risks here by having to disclose this. Because of course, as a company, you do want to put yourself in a nice spotlight, but then consequences will change. But what are the consequences? And here again, happy to discuss this later on. I've taken this from a rather German perspective. What are the possible consequences? Now, obviously, fraud. But what's the fraud? What's the damage in the fraud if I tell someone my car is green? Well, it's still driving. It's doing what it should, possibly not as green. Do I really have a financial damage out of that? That's a requirement for fraud, at least in Germany. So this is quite heavily discussed. Could it be investment fraud? I don't need a damage for that, at least under German law. So possibly here I am having an investment fraud issue. Is it a subsidy fraud if I make false statements in my subsidy claims for subsidies? Possibly. In any event, I may end up in the competition authorities making wrongful statements, and obviously also we may end up in illegal advertisements, something that also came up in connection, for example, with the diesel scandal. And of course, and we'll come back to that in a minute, fines in forfeiture, but because when you talk about corporate criminal liability, or at least the question you ask yourself, why should a company have all of this wonderful circle and compliance and everything? Well, that's what it comes down to at the end, isn't it? It's about the fines, it's about forfeiture, it's about what does it cost. So this is where companies will have to do something. In connection with anti-bribery and corruption, we will, of course, also need to have a look at the development of EPO. And my apologies for repeating this and for stealing these nice pictures from the EPO report. We saw this yesterday. EPO has increased its work quite significantly. It was a very impressive speech yesterday, I found. And so from a defense perspective, this is something we will need to learn, and this is something we will need to deal with. And I'm sure there will be some surprise visits from EPOs over the time, and we'll be forced to learn it the hard way. But you can see by the numbers that we saw yesterday, this is a huge field in the defense practice. Also, this one we've talked about yesterday. That is, when we talk about EPO, I think it's important. This is the first judgment on the dealings with EPO. So from a criminal defense perspective, this is hugely important. But this is also important from a European investigation order perspective. So this is why I wanted to talk to you about this one. This is a case, as we heard yesterday, involving a handling European delegated prosecutor in Germany dealing with a case requesting his colleague in Austria as the assisting a European delegated prosecutor to conduct a search. Now, what happens? The Austrian prosecutor, under national law, is obliged to get a warrant for the search from his national investigative judge. He gets this warrant, and now what happens is there is a search in Austria, and the person concerned is appealing this search. Now, from the outset, it's important to understand that the European Court, and I'll make this short, the European Court is telling us that on the basis of mutual trust and recognition, it is important that the handling European delegated prosecutor is taking care of the justification and the application of this search warrant. So effectively, it is a foreign country, in that case Germany, that is saying a raid in Austria is all right. Now, according to the court, this decision is taken to Austria. Here, another court, that is the Austrian court, can formally assess whether a raid should be conducted, yes or no. And I want to come back to that particular decision in a second. We talked about also yesterday. On that basis of the Austrian court, the assisting European delegated prosecutor is conducting the search. Now, if the person concerned complains against this, according to the European court, the Austrian court can only take care of the enforcement. So let's make it simple. Did the prosecutor, while doing the search, destroy the door? And what happened with that? Was that proportionate? I'm oversimplifying this, obviously. But that's according to the European court, what the national court in Austria should look at. Now I'm asking myself, what did the Austrian court look at when it actually ordered the seizure? Did it only look at the enforcement bit? That didn't happen at the time. Now that decision, in my perspective, from my perspective, to make it very simple, it doesn't make much sense. There's not much that the court can assess when it gets this incoming request. Then, in terms of enforcement, What is enforcement? Let's assume, and we'll come to the topic of privilege in a minute. Let's assume that the German prosecutor is intending to seize legally privileged documents in Austria. Is the fact that a Austrian prosecutor, while doing the search, is taking legal privilege documents, is that a question of enforcement, really? Does it possibly change if the German prosecutor asked the Austrian prosecutor to conduct a search at a law firm? Well, then possibly there may be diverging legal concepts of legal privilege, right? Some of the directives, and we'll come to that in the context of whistleblowing, assume that there is a unique concept and a unified concept of legal privilege. That's my understanding. But if you look at the handling in the individual states, these concepts are so diverging and different that I think this will pose some very, very serious questions in the past, because whatever enforcement means, it is completely open, and in my view, it's quite a limitation for the legal remedies that is happening here, because you can only go against part of this search. But I don't only want to complain. When preparing this speech, I was very happy finding something, and that is a practical issue, at least we are facing in Germany very often, and I think also in other jurisdictions. Again, and sorry for starting with the German perspective again, but we don't have a corporate criminal liability system in Germany. A company can't commit an offense. That's at least our concept. It can be fined, but that's kind of an annex to a criminal offense or an administrative offense by its executives. But then if it gets fined, what is the basis? We don't have sanctions regimes. We don't have certain sentencing guidelines that put a company in a certain space, which then in turn triggers a certain fine. It's very much discretionary in Germany if you talk about fines against companies. Now, when you ask yourself, then why do I do compliance? And why do I do such things as internal investigations, which can be part of number 7 of monitor and improve? Why do I do this? Well, there is some guidance, at least, suggesting that, well, strictly speaking, just having a compliance system just isn't good enough. But then, on the other hand, as you can see here, there's quite expensive lawyers charging nearly 3-digit millions for conducting internal investigations. Now, why on earth would I help the authorities for so much money to even build my case? Why do I do this? When my lawyer comes and tells me, well, usually they take this corporation and this investigation into account positively. Well, would you spend 100 millions of euros on that basis just because someone tells you usually they take this into account? I find this extremely difficult, and this is why I'm extremely happy that was, in fact, in the preparation of this call, to see the proposal on the directive on combating corruption, which, in my view, may be able to harmonize the system of actually taking into account and making it mandatory to consider compliance efforts and possibly also internal investigations as a mitigating factor when finding a company. That would, I think it's not final, right? So that would be a huge step in the right direction from my perspective. And I just wonder whether it's enough with corruption. I would put it into a broader context, but that may happen in the future. So this is a very positive development, I think, in particular from a corporate defense perspective, because it may give certainty if this directive remains in that form. Whistleblowing. You can see I have basically all the topics we discussed yesterday. I'll just touch on them quickly. Again, we have a directive, and For those of you I spoke to last night, you already know my position, but let's start slowly here. We've got the directive. I think this is obviously it's a good thing to have the directive to start giving more comfort, Mikhail, as you talked about it yesterday. In your speech, this is important, but is it effective and does it hit the right targets? And when asked a question that way, you probably know my opinion already now. But where are the issues that I see here? We have a diverging implementation of the directive, and that starts with very easy things such as the fines, which, between the German and the Austrian border diverge more than double, in Germany. The scope of the application, we also spoke about this yesterday. It's a question, is it limited to corruption? Is it limited even more narrowly? Germany has taken a much wider approach, even including administrative offenses, but having all the offenses of core criminal law in there. In Austria, for example, it's limited to the EU triggered violations and to corruption, but not the core topics. If we talk about whistleblowing, we also talk about sexual harassment and things at the workplace, and I feel it would make quite a lot of sense to broaden the application of the directive to also include these types of offenses. Another issue, which I think is very important in terms of providing the comfort you need to go ahead, is the topic of anonymity. And there was a huge discussion on this one in Germany because it was considered very complicated, and also anonymity, I think, in particular in Germany with its history and the former GDR, you are very easily considered as a snitch, and then even worse if it's an anonymous reporting. So this triggered quite a lot of discussion also about the costs for mid-sized company that would be required for that. To my understanding, though, for example, while Germany doesn't require you to implement the structure of formally and anonymously reporting, so you don't need the reporting channel in an anonymous way, Austria, to my understanding, does require such a channel. So there are quite a couple of differences. But I would even go further, and I will touch on anonymity here. And again, I'm coming from a criminal defense lawyer's perspective. Imagine the whistleblower that's coming to me, and imagine that will be, let's say, someone who figured out the LIBOR manipulation or figured out diesel emission scandals, cum-ex, whatever it may be. Now, what's the first question of this person? Mr. Schomburg, am I going to prison for that? What's my answer? Well, for the fact of your reporting itself, you may not be fired, you may not be sued by your employee, but the one about the prison, I'm not sure. Well, that's not the comfort I want to give to my client. The comfort I need to give to my client to make this hugely effective and to get there where we all, I think, want to get, that is this insider coming out, blowing the whistle, letting us know what this is about. That's what you need. That's what you want to have. You don't want some bystander. You don't, well, also possibly you want this one. It's good. But the one you really want is the one who was in it and who can tell you everything. Because that's the one that is going to put the pressure. We talked about this here yesterday, right? In your presentation, you need the pressure. You need an insider. You need the whistleblower who goes first and puts pressure on the rest of the pack. I don't think that the directive in its current form is giving this protection. And I don't know, again, whether this is a question of jurisdiction, but again, in Germany, there's no way I can go to a prosecutor and say, look, I have a client that is anonymous. I don't want to say his name. What would happen, for example, if I would tell you he found out something about diesel cheating? The prosecutor by law couldn't tell me the result and couldn't give me that comfort. I can't give it to my client, and we just may lose some whistleblowers generally would like to do it, but don't do it because they don't get the certain comfort. And this comfort, again, and we spoke about legal privilege before, this comfort is, in my view, is endangered on various stages. Because if you look at the procedure of whistleblowing, we talk about the report in the first place, we have an investigation phase, which may be an internal phase or an external phase, and we have a court procedure. Now, where does anonymity end and where does it count? In my view, in many cases, happy to hear your experiences on that, it will end after the whistleblower report. It will end at the, possibly it will last until the internal investigation phase. But when it comes to the prosecutor, it is very likely to end. Because the prosecutor, also with a view to the right to confrontation of the individual, will need to find out who the whistleblower is, will need, if he does so, put the name into the file, and that file will go to the suspect. And that suspect will know who this person is and will have the ability to confront him or her, the whistleblower. And then you may end up in court if it's a serious matter. Well, your face will be all over the media if you're unlucky. That's not the sort of protection, obviously, that you want to promote. So in the end, what, from my perspective, would be necessary is if a whistleblower comes to me and asks me, what's your advice and what will happen? I need to give him like two pages of a warning that, well, he may be anonymous until and unless a prosecutor requires me to get to say his name, his or her name, until and unless his or her name is in the file, and until this ends in court proceedings. So there's not a promise of anonymity I can give. It's a very vague promise, I believe. So my question is, isn't anonymity a false promise, at least with regard to the criminal proceedings? And the second point, coming from a corporate defense perspective again, is whistleblowing a bar to corporation? Is the anonymity not an issue? Because again, let's assume I represent the company. I got a whistleblower report and it sounds very real to me. And I want to go to the prosecutor and I tell the prosecutor, there is an issue I want to talk to you about. Looks like we've cheated on our digital emissions. Prosecutor, what's his first question? How do you know? Well, there's this anonymous source, but I can't tell you who it is. I think that's a very odd conversation. And I would feel much more comfortable if at that position, we could go and have an easy way of disclosing this, because I don't think that in the end, anonymity will prevail for the reasons I pointed out. So you see, I'm skeptical about this concept. Again, it does give you some comfort, but not sufficiently from my perspective. I'm mindful of the time, so I will just leave these ones and you will find these citations in the presentation in the materials. But I think we have to see whistleblower protection from two sides. So one is the whistleblowing directive, but there's also the European Court on Human Rights, which recently in a judgment called Ale, I hope I'm pronouncing it correctly, repeated an earlier judgment called Guya against Moldova. And in this Halle judgment, the Strasbourg court once again confirmed that whistleblowers fall under the protection of Article 10, that you do have to undertake a balancing exercise. In that particular case, a whistleblower at PwC, an accounting firm in the Netherlands, had disclosed the names of certain customers that were had conducted tax evasion, and he was then, I think, fined to 1,000 euros of a fine, and he appealed this, and the court held that this was not the right thing to do. He couldn't be punished for blowing the whistle there, because there was a prevailing public interest, even against these interests of the individuals on their tax confidentiality rules. So I think this is very important because it adds to the protection from the directive. So cars, it's all about cars. Sorry, I'm German. And we do have issues with that. Coming back to legal privilege, let's have a short look at what I told you and what I indicated before. Now, if you do me a favor and read this section, and then I want to do a poll. Sorry, we don't have any machines for that, but I want to do a poll. And what do you think is protected under German law? Is it the communication with your lawyer? Yeah.
This was not the poll already.
No.
Is it protected?
Yes. It's protected, isn't it? Because what does it say? It does say that those may refuse to testify, and that is defense counsel and lawyers, right? Now we all make that same mistake. Because what the Constitutional Court tells us is, in a decision regarding diesel emissions and the search at a company called, a law firm called Jones Day, no, it's not the correspondence between the lawyer and his client, but it's limited to the defense counsel. Now, I feel that the first citation you see suggests differently, but that is a long-standing interpretation. This is not the first time in Jones Day that the courts did this. But what I want to show you here is that the concept of legal privilege is probably a different one than you know from your jurisdiction, because it is limited in Germany to including defense counsel communication. It's not lawyers' communication. So that puts you, and you remember my case with the Austrian search warrant, that puts you in a different spot, because while under German law, it may be allowed to seize that kind of communication with your non-defense counsel lawyer, in Austria, it may not be. But coming back to the search in Vienna, I think it was, and the Vienna judge only being allowed to review how this search effectively was conducted, well, that puts you in a very difficult spot, I think, because the concept of legal privilege is so different. Also, the concept of legal privilege, as we've seen, which is one of the considerations in the EU Whistleblowing Directive, it appears that when making the directive, it was assumed that the concept would be largely the same. In my view, they're not. And they're not even the same within one country, because if you talk about competition law, for example, you have a much broader protection of the legal privilege in Germany. So that's really an issue from my view. Legal privilege also played a role in two cases. One is still pending. That's the one on the right-hand side. I'll skip this in the interest of time. I think what is important is that legal privilege is being upheld in the case law of the European Court of Justice in a recent decision concerning Belgium. What happened was that also lawyers were obliged to disclose and to report on what they found could be aggressive tax schemes. And lawyers were exempt in that way, and that they should not report to an authority, but were under an obligation to report such suspicious or aggressive tax structures to another intermediary, could be another advisor, not falling within the legal privilege. So apart from, except for bringing it to the authority, on the authorities level, you would report to another advisor, for example. Now, the question was, is that legal? Is that in line with Article 7? Can you force a lawyer to disclose the name and the content, and actually also his view, his assessment of a tax structure as being aggressive, as potentially falling under this under this directive? Can you force the lawyer to do that? I'm very happy to read this judgment, and that it says, no, you can't force the lawyer to disclose name and content and your assessment on a client's perspective and on the client's tax structuring. And it's not only illegal to bring this to the authorities, but it's also illegal to force the judge, the lawyer, to bring this to the attention of another intermediary in this case. And again, coming back and kind of trying to connect the dots, the proposal for the AML regulation takes this judgment into account, so there will be an exclusion for lawyers on this, so the judgment is being taken care of quite positively. Cars, again. But this one, and also in the interest of time, let's be quick on this one. Very important decision from the European Court in the Volkswagen case. I didn't represent Volkswagen, don't worry, so I can speak about this openly. What happened? Volkswagen was fined the minimum small amount of 1 billion euros in Germany, which until today is, I think, the vast maximum that we've ever seen in Germany for cheating with diesel emissions. They got this fine, paid the billion. As I said before, there's no corporate criminal liability, so it's this strange concept of, you know, having failed to implement the appropriate controls, which in turn links then to this fine. So there are quite a couple of legal special issues in this one. But the question, to make it short, was, now that the Italians come into place, can Volkswagen be forced to pay yet another fine? In that case, I think it was from a consumer protection authority. And to make it very short, the European Court said, well, generally no, because Volkswagen already paid a fine, but there may be a loophole. And again, we're coming to topics that we spoke about yesterday, because this loophole, this exception from the principle of nebis in idem, so the prohibition of punishing someone for the same offense twice. The exception applies if you can actually predict that there could be a second offense on this one, which I think is very straightforward in the most cases that are concerning international companies. So in the Volkswagen case, could they have predicted that the Italians would also go after them if you cheat with the cars that you sell in Italy? The clear answer is probably yes, right? Because if you sell a car and you cheat, well, you have a problem. Then the other issue was, is it proportionate? Is it strictly necessary on the duplication? And there was a question of whether imposing the Italian fine of another 5 million would be appropriate compared to the 1 billion that you've paid. And the European Court, without finally determining it, said, well, okay, it's only 5%, it's not so bad. Well, 5 million is quite a lot of money in my world, but still, that will be okay. But the issue I want to get at here, and I think this is also important after what we heard from Eurojust yesterday, is the issue that the court states that coordination is a relevant criteria in whether you can fine a second time, yes or no. Now, why is that so difficult for me? Because I'm only a lawyer. I don't have the privilege as many of you have, that is being an insider into the discussions, for example, on the Eurojust level. Because what happens is that if there is coordination between Italy and Germany on that side, it will probably be facilitated or supported by Eurojust and be within this framework. Now, will I, as a lawyer, ever see what was talked about there? At least from a German law perspective, I don't have access to the Eurojust discussion papers. So I don't know whether there was a coordination. That's what puts me in a very difficult spot. Because if a client comes and asks me, well, can I be fined with another 5 million? Well, I have to give the very bad lawyer's answer. Depends. Depends whether there was coordination taking place or not. Well, how do we find out? The client asks me. And I would say, well, until we have a decision by the European Court or by another court. So we'll only find out later because we don't see the coordination. So there's a lack of transparency into the coordination topics here, which I find not only in this case to be very difficult, because it does make legal advice very hard in this field. And I think this is something that can be worked on. So while I do see some very positive aspects, such as the new directive on corruption, you also see that a small defense lawyer does have some issues with the European perspective at times, and thereby I can conclude my remarks for the morning. And I did it in the style of this conference. I was too late. Sorry about that, Ramin, and sorry for taking the time for questions, but happy to answer your questions if you have any.